public debt is becomes a fast charge, and it keeps on removing from more allocation that is supposed to go to the county. So what the services that somebody in Machakos or Kiambu was enjoying last year, they might not be able to enjoy them this year because of the fact of these fluctuating budgets that are being influenced heavily by public borrowing. And the issues of Article 43 rights, access is becoming an issue because the government is supposed to assist citizens to be able to get these rights for themselves. And for those who are not able to do so, the poor of the poor, then they need to get social assistance through social security. So if taxation is ballooning, people's ability to get housing for themselves, proper healthcare, proper sanitation, food, clean water is also impacted. So the quality of life will continue going down if with public, the public debt is not managed. That's all I have to say for now, Irene. Thank you so much.
Okay, thank you very much, Christine. That was quite elaborate. If you there are any questions, I see a few questions streaming in on that presentation. But if you have like a presentation prepared, you can share on the chat. If not, we will continue discussion on what you have already laid basis on. So please just for participants, keep your questions coming. I'm collecting them. We'll have them addressed after Jane has spoken on her presentation. So I'll welcome Jane. Jane is the program officer at ICJ Kenya. She'll be talking about debt and the judicial options that are available. So ICJ Kenya basically does promotes human rights, justice, and democracy in Kenya and Africa through the application of legal expertise and international best practices. So we'd like to hear from Jen, then what are the legal options or judicial options that are available in terms of debts in Kenya? And are there maybe examples that you can borrow, best practices that you can borrow internationally, or how then, what is available for us? So Jen, you have 5 minutes, maximum 7.
Yeah, thank you very much, Irene. I hope everybody can hear me clearly. Indeed, the issue of debt is something that is of great concern, that should be of great concern to everyone, regardless of the sectors that we are in or the areas that we are working in. Indeed, today, as we speak about human rights issues, we cannot avoid the issue of debt because of its implication on human rights. Even as we deal with the traditional issues in human rights, the issue of debt is clearly becoming of great concern to us. So what are the judicial options? As the speakers who have gone before me have said, there are many, we have proper frameworks. We have a very transformative constitution that has principles, that is based on values and principles that are supposed to govern us as a people, govern us as a government, govern our public institutions, govern public officials. Yeah, it's one of the running themes in our constitution that in every chapter or in every issue, there's the issue of what are our principles and what are our values as a country. So as we speak of judicial options, there is the issue of public interest litigation. You'll note is one of the key transformative results of the Constitution of Kenya 2010. And it gives us the opportunity to go to court, to approach court on very broad issues and be able to present cases regardless of who you are or why you're there. It gives you an opportunity to be heard by the court, which is a real progress. And you can use public interest litigation in this context, for instance, to enforce the principles. As Christine has highlighted, there are principles on public finance management, there are principles on public debt, there are principles on how parliament should oversight public debt. So there is indeed that option of going to court and saying, I don't think these principles are being adhered to. There is obviously the overall principles in our constitution under Article 10 on issues of such as transparency and accountability. There are issues of equality. There are issues of sustainable development, which is one thing that is really prominent in this discussion of public debt. How are our decisions today affecting future generations? And it's indeed one of the global it's one of the key pillars of global discussions at the moment. So you can indeed go to court to seek enforcement of those principles. There is also now the legislative frameworks that emerge from the Constitution. So for instance, there is the issue of the public finance management. What are the principles of borrowing under the public finance management? So for instance, when we say under the Act, we are supposed to borrow for development. Is that what we are doing, or are we using the borrowed money on recurrent expenditures? And are you able to demonstrate that in a court of law? And there are also issues such as the Access to Information Act becomes very critical in this context, because as Christine has mentioned, there's the issue of the whole, the secrecy around these contracts and these negotiations between government and the consequences. More often than not, we only come to learn about the debt we are accumulating after the fact. We never know about the negotiations. We never know how much Kenya is negotiating for. We only learn about the amount once they're here. And it is really hard for you to get those contracts or to get those agreements that Kenya has gotten into. So that issue of access to information is really something that we can take advantage of. Of course, not ignoring the challenges that come with that. But it is one of the issues that one of the acts that we can take advantage of. There are also other acts like Public Audit Acts that basically support the role of the Auditor General. There are also the Office of the Controller Budget. Why is it that until today, despite numerous reports and numerous findings by the Office of the Auditor General on misappropriations at public institutions, at county governments, why is it that we are not seeing that people who are mentioned in those reports being held to accountable? Is also something that we might consider pursuing in court and seeking the enforcement thereof. There are also now the issues of public participation and the broader issues of corruption as an issue in the country, which I've spoken about. So we are saying that the issue of public participation particularly is one of the issues that the courts have been quite progressive about. It's just making sure that there is enforcing that principle, ensuring there is enough opportunity for public participation. However, it's also concerning that now it has now become an issue of checking a box. So public participation is in the manner of 3 days. You're given 3 days to submit your memoranda or to submit your opinion. Those 3 days are between, let's say, the notice is issued today and it's closing on, say, Monday. So when are you supposed to prepare those documents and submit? Do they even take into consideration what you're saying? So indeed, with the support of the jurisprudence we now have, we could take now that a step further and say, now we need a proper framework to define what is public participation, to ensure there are feedback mechanisms, and to ensure there are also ways of allowing maximum opportunity for public participation. There are also issues of enforcement of leadership and integrity principles under Chapter 6 and the supporting acts. So what the liability of individuals and the ability of those individuals to continue to hold office when they have been cited for these issues of public finance misappropriation is also something that then within that context also arises the issue of criminal liability. For instance, we have seen people being prosecuted for corruption issues. So I think at this point, what is also important to note is the challenges that the judicial option poses for us. Indeed, it is not clear on whether judiciary is the right option. Indeed, we do acknowledge that the wheels of justice are quite slow, and it is one of the things that most Kenyans, even in this context, express their frustration about. So, for instance, the time it takes to make a decision more often than not will be very discouraging in terms of why you would consider court as an option. So for instance, if we take the case of the SGR and and the case that challenged the contract or the process by which China Bridge and Roads Corporation came to be the company that was awarded that contract. Right now, we have a decision that says that indeed proper process was not followed in terms of the public procurement. But that decision comes, and I bet now it's being appealed at the Supreme Court. But that decision, the case in itself was filed in 2014, and that decision, the Court of Appeal decision was in 2020. By the time that decision is made by the court, we already have the SGR, it is in place. What do we do about it? So indeed, it is very frustrating to see the time it takes for such decisions to be made can be discouraging for courts as an option. There's also the issue of access to evidence. Because we have said it's very hard for you to obtain these documents, it becomes then the issues and the way our legal system is structured, it becomes difficult to use those documents if you obtain them otherwise than through those, the processes that are there to use them in court as evidence. So indeed, that is also a challenge. And again, I cite the same case, the SGR case. You can find it in Civil Appeal number 13 of 2015. There was that issue of how the documents that Okoa Omtata and the other petitioners were presenting before court, how they had obtained those documents became an issue. And in the end, both the High Court and the Court of Appeal held that they could not be admitted in court as evidence because they were not obtained through legal means. So that is indeed another challenge. Then there's also the challenge of the independence of the judiciary. I think this is a conversation that is really of importance to us as a country, because unless we have a judiciary that is able to make bold decisions without being intimidated or without being told there will be consequences of these decisions, then it becomes difficult for them to oversight the executive or even to oversight parliament. So we must look at this issue of the independence of the judiciary from a very broad perspective. Indeed, if we want a judiciary that is able to even speak to such critical matters, then we must be able to ensure that the judges and the judiciary as a whole feels that it has the space to make those decisions. There is also the issue of technical expertise. We note the running joke among lawyers is that MADS and us are not do not get along very well. So we must be able to combine economics and the law to be able to explain. So when we say the percentage of debt against our GDP, we must be able to explain it to the court in the most simple way, such that the court is persuaded that is indeed this is an issue that we need to address. It must be that even in our approaches in litigation must really take into consideration expert evidence from an economical perspective, so that they break it down and tell us this is the consequence, this is what we are looking at as a country. And so if you look at, I'm just wrapping up. The final part will be, what solutions then do we have? As I mentioned, there's the issue of combining expert evidence is very important to us, so that you combine the economics of it and the law and you break it down before court. There is also the issue of safeguarding the independence of the judiciary. We must be very intentional about it, so that we ensure we have a judiciary that is able to make bold decisions and, for instance, say no more borrowing for this country if we do approach the court that way. There is also the issue of our strategies in litigation have to be very smart. We should not be afraid to present prayers that really will make good jurisprudence. So for instance, there are issues of the odious debt principles, which basically means illegitimate debt. Are those principles that we have invoked before court? I don't think at this point we have, but those are considerations that we can make when we speak about the issue of accumulating debt and lacking the capacity. That is one of the things that we can do. There is also the nexus between the social economic rights and the ballooning public debt. How do we combine these issues so that it's not just an economic issue, it's also a human rights issue, and we are able to make a case before court in that sense. there is also the issue of what are the gaps in law. So for instance, if we cannot access information through the channels that are there in access to information, do we have proper frameworks to protect whistleblowers? So those are considerations that we'll be making. And it's important for us to think about them as important tools in our quest to use the judiciary in addressing the issue of public debt. I think in conclusion for me, having noted the challenges that the judiciary faces, or the challenges that come with judiciary as an option for this, I think it's important that we note that cases will not work as sole standing. We must accompany them with advocacy efforts. We must accompany them with other efforts towards, for instance, forcing Parliament to exercise its oversight role under Article 211 of the Constitution. What is Parliament doing about demanding that information on behalf of us as Kenyans? And for instance, telling us between March and now we have borrowed 360 something billions. How has that money been spent? It is there in the Constitution, but is Parliament doing that? We are all here expressing our concerns, but Parliament, which has power in law to summon or to demand that information from the executive, is not doing it. So what are we doing about that? So I think it's very important to note that advocacy and engaging these other institutions, the Ethics and Anti-Corruption Commission, the Office of the Controller of Budget, the Office of the Auditor General, must accompany our pursuit of judicial options. I think I'll leave it at that and leave it to the for more discussions in the plenary session. Thank you.
Okay, thank you.